roots and became entrenched, what the world had never been told all along is that there was not one decision, not two decisions, not three of them, but in fact, the courts of this republic, presided over by judges and magistrates of various cadres, of various qualifications, of various ethnicities, of various races, all of them, in all those allegations, without exception, ruled in favor of the man. You have now been told, to use the mover's words, the world has such a bad perception about him. He's a man of such terrible character. And because he has been given such a terrible name, if the Honorable Wamboka says he's a murderer, then we take it line, bait, hook, and sinker. Because this man has been painted for 5 years as a crook, as a fraudster, as whatever you may wish. If Honorable Wamboka says this man is implicated in the fertilizer scandal, then it must be true. After all, the allegation is made against the Honorable Linturi. It is in that context we submit to you, and I'll be showing it shortly. It is not coincidental. You kept hearing from the mover, from his counsel, that perception is enough. Because we have such a bad perception, such a bad single story about this man. We should send him to the guillotine, we should crucify him, and if we allege he has killed somebody, we don't even apply our minds. It is Linturi after all. If we say he has stolen somebody's wife, we don't apply our minds. After all, it is Linturi. If we say he was in the fertilizer scandal, yeah, we can shut our minds. You mean it's Linturi? Yeah, it must be true. And that is the context in which I beseech you to watch before you deliberate this very famous TED talk show by the graceful lady from Nigeria about the dangers of a single story. But why am I warning us about these dangers? It is because our system of justice itself, whether it is Article 50 of our Constitution, whether it is the oath of office for judges that I alluded to 2 days ago, whether it is our Article 49, whether it is our Article 47 that the Speaker himself referred to when he said about these proceedings being quasi-judicial, whether it is the Evidence Act, I could go on and on and on, but the point I'm trying to tell you is that all these instruments are founded on the assumption that you cannot approach a matter such as the one before you from the perspective of a single story. Section 55 of our Evidence Act in subsection 1, and I read, says, Honorable Chair, that in civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is inadmissible. Those are not my words. It is the words of our Evidence Act as written by the British in the year 1872, they later on exported to Kenya in the year 1897 through the East African Order in Council of 12th August 1897. That's how long ago Kenya adopted a law on the dangers of a single story, and the long and short of it is you have been told in black and white that the fact that the man accused before you is a man with a terrible character, reputation, disposition, or whatever, is immaterial and inapplicable. Section 57 of the same Act again says, Honorable Chair and members, that in criminal cases, the fact that the accused person has committed or has been convicted of or charged with any offense other than the one with which he is then charged or is of bad character is inadmissible. It is in that context that our Constitution says everyone enjoys the presumption of innocence until his guilt is proved, and I'm here shortly to show you that the guilt of the Honorable Linturi has not been proved. I'll read for you again, Honorable Chair, a decision of the famous House of Lords, again issued in the year 1893, that is 131 years ago, about the dangers of a single story, the dangers of prejudice, and it is a decision called John McKean and Sarah McKean versus Attorney General for New South Wales. Just in case your staff want to retrieve it for you, it is in the 1893 volume of the appeal cases at page 57. And if I may read what one of the most famous judges in the Anglophone world ruled in that case, quote unquote, it is not competent for the prosecution to adduce evidence tending to show you that the accused has been guilty of any criminal acts other than those covered by the indictment for the purpose of leading to the conclusion that that the accused is a person likely from his criminal conduct or character to have committed the offense with which he is charged. Honorable Chair, I'm making all this because contrary to what the spinning that has been attempted, it is not Honorable Linturi that brought to you that the two cases of love and affection as the basis for the accusations before you. It is the mover of the motion who has listed these cases in ground 2, and he is telling you because there were those cases, never mind they were all without exception determined in favor of the Honorable Linturi, he's telling you, yeah, he has such a bad perception, let us crucify him. Again, Chair, this will surprise many of us. And because it will surprise many of us, I want to say it slowly. A lot has been said about democracy, about the 149 votes that voted in favor of this motion. A lot has been said about poor, suffering farmers. I'm here to very politely tell you that, again, our law forbids you from considering any of those things in Article 52A about the presumption of innocence. I'm here to tell you, actually, we have a decision on whether public sentiment, democracy as we call it, what the masses will, is a relevant consideration in a matter like the one before you. And why I said it will surprise many of us is, one, it is of course forbidden by the constitutional provision on presumption of innocence. It is forbidden by all those cases I have read and those sections. But there is actually a South African decision again called S versus Makwanyane, which I hope your secretariat will retrieve for you, that says in black and white, the fact that the masses are being out there, crucify him, is not a relevant consideration, not when you're sitting as judges. And I think I said previously, you're seated here not as the representatives of your constituencies, not as members of parliament. The Speaker himself said you're sitting as a quasi-judicial tribunal, and justice is required to be administered without regard to the clamor and the seductions of a baying mob. What is the allegation against the Honorable Linturi? We said there are three, Honorable Chair. And in the first one you're told, it appears. You have not even been told Linturi has done it. You have been told it appears that he is guilty of gross violations of the Constitution. You know, when I was in law school more than 20 years ago, Chair, we were taught in a subject called criminology some controversial theories where you would look at a person's features, how big their ears are, how long and crooked their nose is, whether they are squint-eyed, whether they have a goatee, whether they have rough hairstyle, and based on those apparent features in that discredited school of criminology, then you could conclude this one must be guilty of the offense charged. That is what the mover brought you. He told you, it appears the man he seems to be very unhappy with has committed a gross violation. I have looked at Linturi for several years. I don't know whether I have seen it appearing, and I urge you to look at him in the room and tell us, how would you, looking at that gentleman, conclude it appears? You know, because I don't like his face, therefore he must be guilty of the offense. Can we in good conscience, Honorable Chair, say that a man or a woman is guilty, not just of a violation, but a gross violation of our Constitution because it appears when we look at him, I don't know whether with our glasses in my case or with the naked eye or under a microscope, we weren't told how he was looked at to arrive at this conclusion. And of course, when we pushed this in cross-examination, the answer we got is that he has such a bad public image. He has such a terrible reputation, which unfortunately we were able to demonstrate to you beyond any shadow of doubt is a reputation that has been created by the previous administration merely because him and others who are subjected to different forms of persecution were in support of the presidential candidature of the Honorable William Ruto. You're told in allegation 2, Honorable Chair, unfortunately this is the allegation on love and affection, you're told there are serious reasons to believe that the Honorable Linturi committed a crime under national law and certain sections of the Penal Code were cited. The material that was placed before you, not by the Honorable Linturi, but by the move of the motion, was some 32 cases that arose from a relationship gone sour. And Honorable Chair, I found myself asking a number of questions, which I urge you to join me in also asking yourselves. When the drafters of our Constitution drafted that document, and specifically drafted Article 152, did they intend that Article 152 on dismissal of cabinet secretaries could be invoked to pursue matters vendetta attributable to personal love and affection? That's question number one. Because it is the mover who has based that ground on matters of personal love and affection. Is that what the drafters of our Constitution intended to be the use for Article 152? But, Honorable Chair, can failure to fall in love with someone, love is supposed to be voluntary. Can love be forced at the risk that if I refuse to fall in love with someone, then if I become cabinet secretary someday, they can bring a ground like ground 2 before you? This one I ask for my own personal reasons, Chair. When I was in the love market, I was quite prolific. And I have a number of exes. And I want to believe I have the potential one day to rise to be also a big man like Linturi and the honorable members of this committee. And I've been wondering, should God answer those prayers? Will one of my exes look for a member of parliament, give them 32 personal disputes, and tell them, use this as a ground to ask His Excellency the President to dismiss Dr. Mudomi as a cabinet secretary? Is that really why we adopted our 2010 Constitution? But more importantly, I found myself asking a third question. If the courts of Kenya, all of them, have ruled in favor of the Honorable Linturi, you know, if we are talking one case, Honorable Chair, we would say it was a random luck, that's why he won. If we were talking two cases, or three, we would say it was a string of luck. But we are saying the Honorable Linturi won all these 32 cases in the courts of the Republic of Kenya, spread across the entire judicial hierarchy. So the question is, will Linturi have to win these cases before the Honorable Member for Aldai so that he can have peace? The question of principal chair. Can the House in good conscience, can this committee in good conscience advise His Excellency the President to dismiss the Honorable Linturi because of cases of personal love and affection which all the judges of Kenya have ruled in his favor? Does this committee even have capacity to sit in appeal against decisions rendered in all those 32 cases? The fourth question I found myself asking about this matter before you, let's even assume for a moment that these were not matters of personal love and affection. Let's assume they were more substantial things for argument's sake. But it is common ground that these cases were considered by the House when it approved the nomination of the Honorable Linturi as a Cabinet Secretary. And the million-dollar question for me is, can this committee sit in appeal against the resolution the House made in 2022, 2 years ago, to approve the nomination of the Honorable Franklin Mithika Linturi as a Cabinet Secretary, notwithstanding those cases? Allegation number 3, Honorable Chair, was that the Honorable Linturi is guilty of gross misconduct for two reasons. One, it was alleged he was in a public spot, not a private spot in some private residence. No, a public spot with journalists. No journalist came to testify before you. No journalist saw a witness statement before you. Even the request for summoning witnesses, it is quite telling, and I know you have ruled on it. There was no request to summon any of those journalists. This room is full of journalists. I expected, even if there were difficulties, they could point to one of them and say, it is that one who was involved. Let it come here and explain to this committee about this part. Journalists work with cameras, and I mean video cameras. We live in a world where everyone has a mobile phone to record a public spot. You are not shown. Now, even if we assume Linturi is the alter ego of Lucifer, surely we cannot advise His Excellency to dismiss him for this allegation. Even if we were to assume Linturi is the twin brother of Lucifer, this is an allegation. They say, Mgala mhue na haki umpe. You may not like the guy. You may hate him to the core recesses of your heart, but you must give him justice. You are told the second reason why we should advise the head of state to dismiss Linturi is he revoked licenses for some factory. First of all, you have not even been shown the license in the first place, because for a license to be revoked, it has to exist first. You have not been shown this is the license that was in place that the Honorable Linturi revoked. You have not been shown an instrument of revocation. Licenses are granted in writing. They are revoked in writing. The Honorable Linturi, as a Cabinet Secretary, is not even a licensing officer. under any regime of the law. We have more than 1,000 chapters of the laws of Kenya. There is none in which the Honorable Linturi or any other cabinet secretary for that matter is a licensing officer. Licenses are issued by regulatory bodies. So the question, therefore, again, even if we accept Linturi this time is not the twin brother, he is the devil himself, as we've been invited to believe. Can we really, in good conscience, in this historic occasion that is not precedented in the history of our republic, advise His Excellency to dismiss this good gentleman because there are serious reasons to believe he has committed a gross misconduct. You are told, Honorable Chair, still on this ground 3, that the evidence is a press statement. And I recall asking you in my opening, Chair, I know we say many things about democracy as a developing project in Africa, but I would be interested to know which country in the world, in which country as a cabinet secretary or even a sweeper of our streets, forget a cabinet secretary, has been dismissed from office because somebody somewhere issued a press conference over a matter they did not even witness. We were told yesterday when we ran the Evidence Act, you must have seen it with your eyes, you must have touched it with your fingers, you must have heard it with your ears. The author of this supposed press conference is Common Ground. They are not a journalist. It is Common Ground. They have not sworn a witness statement. It is Common Ground. They didn't come to testify. But nonetheless, because they believed. Or are we going to say because this press statement was issued by none other than the President of the Law Society of Kenya, therefore if the President of the Law Society of Kenya has issued some press statement, and this press statement is against that devil called Linturi, therefore we shut our mouths and say, crucify him. Heads must roll. Blood must let. I'm resisting the temptation, Honorable Chair, to say that this motion is very unfortunate because it is unfortunately trivialized. It has trivialized some important constitutional accountability framework. You know, we would expect if this very grave accountability mechanism is invoked, it has to be invoked on the right occasion, on the right facts, on the right allegations. That it could be invoked because Linturi has refused to fall in love with someone, because Linturi has refused to marry someone, because Linturi has such a bad perception, because Linturi has such a bad reputation. It is to trivialize and, I dare say, Chair, to scandalize our Constitution. Chair, I seek your protection because when the other side was speaking, it was listened to in silence. And I said, I am not a young child. I know my limits. I am a married man, as I said, to a beautiful wife and 3 children. So I'm just doing my job. Let me be allowed to do my job without interruption.
Members, let us know that this is the closing remarks, and let us allow the Council to proceed without any interruption. Thank you.
Thank you, Chair. You were told the other reason, Honorable Chair, is because some lawyer issued a demand letter. And because this lawyer issued a demand letter accusing Linturi at the instruction of his client of some wrongdoing, therefore there are serious reasons And I kept asking in cross-examination and examination in chief, Honorable Chair, I have practiced law for 17 years now and counting, and every day of my professional life for those 17 years, the very first thing I do in any assignment is to issue a demand letter. I don't know how many people would have lost their jobs if the letters authored by me on behalf of my clients were the new standard for having a cabinet secretary, and as I said, God forbid, even our street sweepers dismissed from office. That's the context in which I say we have been treated to a cruel joke. This joke is cruel because it invokes one of the most important provisions of our Constitution, and it invokes it in vain. You know, we have a commandment that says, don't invoke God's name in vain. And our Constitution is not just another document. It is the most important legal instrument in this republic. It is the supreme law. It begins in the first clause by acknowledging God. And here it is being invoked in the most frivolous, in the most trivial manner, because Linturi is, after all, such a bad guy. Where is the evidence, I dare ask? And I repeat, where is the evidence that supports either allegation 1 or allegation 2 or allegation 3? You know, Chair, it is not every material that a disputant presents to you that counts as evidence. When you read Section 2 of our Evidence Act, you'll find it says, evidence connotes the means by which an alleged matter of fact, the truth of which is subjected to investigation, which is what you're doing, is proved or disproved. What is the material or the means the mover deployed to prove or disprove the 3 allegations before you? And when I found myself reflecting on this again, Honorable Chair, it reminded me of a common adage, which again I didn't know. I first heard this adage when I was in the love market many years ago. And I recall a classmate of mine, me gesturing like young men do. I was a young man then, and I recall her telling me, Mudomi, beware what you pray for, as the gods may just grant it. It is a common warning. I think there is even a biblical version of it in the book of Acts of Apostles, only that I said I'm a man whose interaction with religious texts is sporadic. But the adage, Honorable Chair, says, beware what you pray for, because God might just grant your prayer. What did the move of this motion pray for? Very passionately. He prayed that he be allowed to bring witnesses who had not even sworn any witness statements or affidavit, and this tribunal was gracious enough to grant that prayer. What happened after his prayer was granted? He brought Titus Kiprotich, who told us that he did not even know that his statement would be used in these proceedings, and he had not even read the proceedings. And he told us something even more curious. He did not even know the identity of the person who procured him to come and testify before you. He brought Bernard Kuria Wajiko, who told you without blinking his eye that he had not read even the motion and he did not know the allegations against the Honorable Linturi. This gentleman had bought a fertilizer called Mavuno, which is not even one of the fertilizers that are in contest. Then he brought David Maina, a man presented as an expert, I would say perhaps in his own imagination. He was not registered as a farmer. he was to come here and testify to you about some expert reports that he had not authored, that had been given to him by some lady whose name we were told, and that was supposedly used in the now famous, I dare say infamous, expose by Africa Uncensored. This guy proved nothing. He was incapable of proving anything anyway. Sami Kiptum Brigade also told you he had not even read the motion. He did not know what were the allegations against Linturi. He also bought that irrelevant fertilizer. Osea Kipkete Ruto, who was the last witness, also told you he had not read the motion. Some of these witnesses, when you read their witness statements, the reason they say the fertilizer was fake was because they used top-dressing fertilizer for planting. And then they tell you, as a result, the maize never grew beyond the knees. Of course, the maize will not grow beyond the knees if you use a top-dressing fertilizer as a planting fertilizer. Honorable Chair, when you make your decision, I pointed earlier, there is no recourse, there is no non-recourse against your decision in our legal system. And reading our Constitution, I'm now able to appreciate the wisdom of its drafters, Chair, when they said that the House shall form a committee to investigate, instead of simply saying the House shall vote. It is for good reason. And this good reason is that it is that tension in the Constitution between two things, democracy and justice. Those are core values of our Constitution, Honorable Chair, and they don't always pull in the same direction. Democracy will say, because the masses are telling Pontius Pilate, crucify him, never mind whether he has an offense, then, because that's what the people are asking for, you crucify the guy. That is democracy, the will of the people. That is the 149 votes. And I dare say it is because of this natural tension between democracy and justice that the drafters of our Constitution in their wisdom decided there shall be an inquisitorial committee and its proceedings shall be quasi-judicial. I'm saying there is zero room in Article 152 for lynching, for crucifying him, or for starting a chorus. You know, the problem with democracy, Honorable Chair, and why it is always at loggerheads with justice, is in democracy, you start a chorus. Like before Pontius Pilate, crucify him, crucify him. If you go to any other democratic setting, like on the floor of the House, Linturi must go, Linturi must go. That's democracy, but it's not justice. And that's why this committee exists, to now walk that tight balance, because both democracy and justice are values in our Constitution, and I dare say, Honorable Chair, our Constitution has already decreed if there is a tension between democracy and justice, it is justice that prevails. That is why the right to a fair trial is absolute. When you read our Article 25, it says one of the rights that cannot be limited, not even by Parliament, not even by His Excellency the President, not even during war, not even during a state of emergency. The right to justice is absolute. Those are not my words. It is the words of our Constitution. I end so that I don't take away my learned colleagues' time by reminding you, Chair, because you're sitting as judges, I said last time, it is the only human enterprise where human beings take the seat of God to pass judgment against other human beings, to end careers, to end businesses, to separate families, to impose lifelong shame, to impose lifelong ignominy. It is only in the seat of a judge, which I dare say is the seat of God. Both dominant religions in this country depict God as the ultimate judge, and they even talk of a judgment day in which God seated on the throne will be judge numero uno, passing the ultimate verdict at the end of time on every one of us. And luckily, even this committee, for those of us who believe in religious texts, we shall also be judged that day for how we judged the Honorable Linturi. And I dare read, like I read last time, the hadith. We were told from Islam, judges are of three types, one of whom will go to paradise and two to hell. The one who will go to paradise is a man who knows what is right and gives judgment accordingly. But a man who knows what is right and acts tyrannically in his judgment will go to hell. And a man who gives judgment for people when he is ignorant will go to hell. That is the hadith number 3566 from Islamic teachings. When you're being told about farmers, which I've already told you, those cries cannot be the standard. You're being asked to act tyrannically. You're being told, like Pontius Pilate, to crucify this guy. You must crucify him. That's what you're being told. Because there were some 149 votes. And I've just told, even if there were 349, that would not be the standard. And of course, we were told in Matthew 7, do not judge, or you too will be judged. In the same way you judge others, you will be judged. And with the measure you use, it will be used to you. Why do you look at the speck of sawdust in your brother's eye and pay no attention to the log in your own eye? I beseech you, Honorable Chair and members, this motion before you is a petty calumny. It is a petty gossip about personal love and affection. It is a witch hunt. And because it is all those things, we would be scandalizing our Constitution on the occasion of today if we were to say the Honorable Linturi should vacate office merely because he has been a victim, as he told you, for 5 years of state-sponsored vilification, defamation, and shaming by the previous administration. I cede the remaining minutes to my very able and learned Boniface Mwereru Mawira.
Good morning, Honorable Chair and the members. It's afternoon, I'm sorry, good afternoon. I'll begin from where Dr. Mudomi has left. Honorable Chair, the linchpin or the substratum of this impeachment motion is what we are told is the approving. In fact, I think I should read verbatim. Approving the procurement and distribution of fake fertilizer. That is a substratum of the special motion before you. And yesterday during cross-examination, we pointed out Section 69(1) of the Public Procurement and Asset Disposal Act, which says that all procurement decisions by law, and none was forthcoming. So, Honorable Chair, for me, it's a question of principle. Can this committee, and to quote Dr. Mudomi, can this committee in good conscience advise His Excellency the President to dismiss the CS when this written approval has not been presented before you? Even worse, Honorable Chair, the procurement function, as by law, is a function of the Secretariat of the NCPB. The function of the CS ends in appointing the board. It is not the board, or rather the board members, that are directly appointed by the CS who are involved in procurement. Procurement is a function of the Secretariat, and the approved organizational structure that we presented before you clearly shows that there is a manager procurement and other competent officers below him or her who perform this procurement function. So that function cannot, by the mere word of the mover, be placed on the foot or on the door of the CS. There's another allegation, Honorable Chair, that was introduced midway. And I appreciate and commend my learned senior Dr. Amino for his contribution to the current constitution that we have as a country. But this same constitution says, under Article 50, I believe under Article 52B, that a man or an accused person has the right to know the charges that are pressed against him and to have sufficient detail to respond to those charges. So for me, Chair, it's really a question of, for how can the CS, because a lot of heavy weather has been created around this issue of the fertilizer, the board under the Fertiliser and Animal Foodstuffs Act, which allegation is not in the motion. For how can the CS be convicted with respect to a charge that is not in the motion? Is it permissible for the mover to introduce charges by word of mouth midway? Is it permissible for the mover's case to keep changing, to keep mutating, without giving fair notice to the CS for him to respond? That charge was introduced on the floor, and the CS responded on the floor. But by Article 50, being the accused person, the CS deserved the right to fair notice, the right to know the charge in advance, and the right to prepare an answer to that charge. So to the extent that that charge was not in the motion, then the CS cannot be convicted with respect to that charge. More importantly, Honorable Chair, and as we saw in Sonko, the Sonko decision by the Supreme Court, the allegations must be serious, to read verbatim, they must be serious, substantial, and weighty. All these allegations that we've been told about reputation, character, general responsibility, perception, all those allegations, they are not in the realm of specific acts that are attributable to the CS. There must be an nexus. And Honorable Chair, I am aware of the rule that you've made with respect to the issue of summoning witnesses. But allow me to say that when the mover was on the floor the day he made the application for the PS, and I believe the CEO for KELS to be summoned, he said that, especially for the PS, he said it was necessary to summon the PS in order to establish some necessary links. And he adduced some letters before this committee, most of which were not even copied to the CS. The CS was not even aware of those letters. So, how can it be possible then? And this is a question of law, Honorable Chair. The law on summoning witnesses is that you do not summon witnesses in order for them to fill missing gaps in your case. So to the extent that the mover sought to summon those witnesses to fill these gaps, to establish these necessary links, according to him, this is an admission that indeed he has not established the necessary nexus between the CS and the allegations that are stated in the motion. Honorable Chair, while Council was submitting, in her closing remarks, she talked about some former heads of state somewhere who have resigned. And I think it is important to make a clarification that there's a very rigid dichotomy between resignation and impeachment. Resignation is a question of political responsibility, while impeachment is a matter of law. In fact, if someone resigns, mostly it is voluntary, and that person can seek elective office in the future. But if you are impeached, as our Constitution says, or if you are dismissed or removed from office, you face a sentence of eternal condemnation from public life, from public office. So the question, impeachment is a question of, first it's a legal question, and then there's an evidentiary threshold. It's not akin or similar to resignation. And we have seen, for instance, the example she made, President Jacob Zuma, he resigned. But last week, the Constitutional Court of South Africa cleared him to run. He can seek public office. But if someone is impeached, they are eternally condemned from public life or public office. And for President Zuma, there are specific acts. You know, all this story about the Guptas, about the rural home that was built for him using taxpayers' money in Kandla, somewhere in KwaZulu-Natal province, those were specific acts that were attributable to him. Council talked about the former president, I think, of Hungary, about clemency, the presidential pardon. That was an exercise, a specific act of the exercise of presidential powers of mercy. So even for these guys who resigned, there were specific acts attributable to them. And clearly, the threshold for impeachment is far much higher. It is not akin to resignation. Honorable Chair, we've been told about this expert. I'll just add something little over and above what Dr. Mudomi said. This expert did not even present the necessary credentials before you to prove that indeed he is an expert. Should we just take his word for it that he's an expert? Even more importantly, the report he presented before you was not prepared by him. He did not conduct the analysis, he did not conduct the testing, and therefore he is speaking about a report that was prepared by another expert, but not himself. Honorable Chair, the consequences of the decision that as you retire to make the decision that this committee will ultimately make, the consequences are untold, especially for the CS, because for him, he possibly, and I say the word possibly, stares at possible condemnation from public life, from public office. So is it proper, as a question of principle, for a mover to present witnesses before you, witnesses who have not read the motion, some are not even aware of who the CS is, witnesses whom I would say were duped. They did not even know that there was a motion, they did not even know the mandate of this committee. Can the mover properly say that he has proved his case to the required standard if these are the witnesses that he brought before this committee? Clearly, Honorable Chair, the mover has not discharged the burden of proof on his part. The burden of proof was on the mover. He told us that he needed some other witnesses to help him establish these necessary links, to establish these nexus clearly and admittedly. The mover was telling this committee that the evidence he has before you does not point, does not implicate, does not, state these specific acts that are attributable to the CS. And with that in mind, as you retire, Honorable Chair and the Honorable Members, then justice, as you retire to render justice, it is important to have in mind that justice, the scales of justice, are akin, as we said previously, to a coin. There are always two sides. So, will justice have been done for the CS if, indeed, he is removed from office, or rather you make a recommendation to the President to dismiss him from office, when the mover himself admits that he has not discharged the burden on his part? There are some necessary links that he has yet to establish. The witnesses, his own witnesses, rather, had not even read the motion. They don't even know the CS. Honorable Chair, the mover must rise or fall with the charges as framed. The Constitution abhors trial by ambush. If he did not find it fit to give the CS sufficient notice of those allegations, especially on the Fertiliser and Foodstuffs, Animal Foodstuffs Act, then he must rise or fall with a motion as approved by the House. He cannot introduce these charges midway without fair notice to the CS to respond. The last point for me, Chair, is that
you have 35 seconds. Kindly conclude.
Thank you, Chair. The last point for me is it proper? Is it proper for the mover, and personally the mover, not now his counsel, is it proper for the mover, I believe as a ranking member of the House, is it proper for him to cast aspersions and make us unsupported claims or implications of bias against the committee? So, Honorable Chair and the honorable members, we pray and beseech that we do justice to the CS and all other public servants in this country who have been castigated unfairly, and as we've seen for him, over 5 years. State prosecution for the democracy that Dr. Amino says he hardly fought for. Thank you, Honorable Chair.
Thank you very much. That now brings us to the end of the closing remarks by both parties, and I will proceed to give my closing remarks as we conclude this. Honorable members, the closing statement by the sponsor of the motion and the Cabinet Secretary marks the end of the investigation process. On Wednesday, 8 May 2024, we had an opportunity to hear the evidence of the sponsor of the motion, Honorable Wanami Wamboka, MP, and 5 witnesses. Yesterday, Thursday, 9th May